get to see all the greatness I possess, endless possibilities. Look in the mirror, what do I see?
Welcome to another segment of Seek Elevation with yours truly, Attorney Alakisha. Today, it is me and you. I have 7 questions that I'm going to address. 7 questions to ask when starting a business. And to be honest with you, it's not just when starting a business, it's with running a business. So welcome today. I'm excited about it. This is where real issues, real people, real conversation takes center stage, because change doesn't happen in silence. And if it's dealing with sports, to entertainment, to business, and just the community, we elevate voices that need to be heard here. So we don't just talk about it. We empower, we inspire, and challenge the status quo. That's what I want to do, segment upon segment upon segment. From bringing guests in to me, it just being me and you. So we're going to talk about today some of the important things you should be asking, again, when starting and running a business. And for some of you, to be honest with you, even if you've been running a business, with the 7 questions we talk about today, you may realize that, whoa, I may need to start on a few things right here and right now. And it's important for us to talk about that. And as I mentioned earlier, I am an attorney, but the information I'm going to talk about today is not giving you legal advice. I am giving you legal education. I'm giving you legal information for you to take and to drill down on it, for you to educate yourself, and then you can hire whoever you feel moved to hire to actually apply this information, to actually go deeper. But I cannot possibly give you legal advice if I do not know your specific situation. But I am going to empower you, because now is the time. More now than ever. We need to get it right. We need to not just be moving. So I'm here to bring my experience, my knowledge, and all the things to help you. I'm not going to drill too deep down into these 7 questions, because it can become overwhelming. And to be honest with you, one question can literally take an hour, because a lot of times I'm consulting with individuals just on one question, and we're taking up our 45-minute consultation time just to drill on that question. So I'm going to give you enough, though, for you to walk away and say, wow. So make sure that, you have a pen, paper, notepad, whatever it is, your iPad, phone, notes, and jot this stuff down so we can move. This is important to know. You can move differently. It's important to know this information, because lacking in these 7 questions, and there's plenty more, but this is a foundation. Lacking in these questions are a reason why a lot of businesses fail, or they're not taken seriously. A lot of people don't realize that, when you're trying to elevate, you're trying to escalate your business, and you want to talk about your business in different rooms, there are things that decision makers are looking at other than the product or service that you have to offer. They're also looking at, how everything is packaged and how seriously should they take you. And some of the things that we're going to talk about tonight is going to address the questions you should ask yourself and answer in order to be taken seriously. So, if you're listening, grab someone, tag, share. This is really important information. If you know someone who is starting a business or been running a business, share this. It's all beautiful, all, glitz and glam when we say we should all just be entrepreneurs. We should all own our thing or own something. That's great. But there's responsibility and accountability that come with that. And we need to know what that is. So let's go ahead and get right into it, because I want this to be something where I captivate your attention, keep your attention, and hit all the points within a reasonable time so that I do not, lose you on anything. And I shouldn't, because if this is important to you, you will stay attentive because it's important. So before you get, that business entity, or when you actually establish that business entity, before you hire that team or sign that contract, or you may have signed it, I want you to either pause if you haven't done these things yet, and I want you to extremely listen if you have. Because what you don't know legally can cost you everything. It really can. And I know a lot of times the most important thing that we feel we should put in the forefront is marketing, branding, even sometimes coaching. You establish all of those things, but if you're not asking these questions, you may not be legally sound, and all the things that you put up front will come crumbling down right with you. So we're breaking down these top or common questions every aspiring business owner and current owner must ask themselves in order to protect their vision and build real ownership. There's some words that we just throw out there with no substance, but we're going to start having substance. We're going to build real ownership. Let's turn confusion into clarity, and let's turn this paperwork into power. So the first question, this is what you need to ask yourself, right? This is the first thing that you should start with. What is the best business structure for my goals? What is the best business structure? And there's different types of business entities that you can establish, different type of business structures that you can think about. And once you start, just have a product or service and you start offering it to the world, you actually establish a sole proprietorship. And a sole proprietorship is a business owned and operated by one individual, as it sounds, a sole. And you have this proprietary interest into whatever it is, your products and services. It's owned by you. Once you start doing that and you offer yourself to the world as one individual, you are operating as a sole proprietor. Sole proprietorship is not a separate legal entity. And that means that you as the owner, you as the sole owner, and the business are legally the same. If something was to happen, if someone had an issue with your business, they also have an issue with you. And you as the owner, you're personally liable for all the debts and obligations of the business. And all of the income and expenses are reported on your, personal tax returns. But it's easy to start, right? Because you don't have to go to the Secretary of State. You don't have to do anything. You just need to start. So it's simple to establish, just go. But it exposes you as the owner to unlimited personal liability. So when you're out here and you may have some individuals just doing anything, just decide I have a hobby. I'm going to create, this jewelry. I'm going to sell water, whatever it is. Once you're selling something, you have now created an obligation for yourself to do all the things correctly, or you can be personally liable for not doing so. So that is a sole proprietor. So you have to ask yourself, what are my goals? Is this something that I'm willing, I'm able, and ready to risk doing without establishing any type of business entity structure? And if so, then for some people, you operating as a sole proprietor, and that's a sole proprietorship. Now, in the same vein, you have, that's one person just on go. Now, if you have two or more individuals who's just on go, they just start, they have a product or service and they decide to sell it to the public, then those two individuals also don't have to establish a legal entity with the Secretary of State. They can just go ahead and get going, just like the sole proprietor. The two or more individuals who co-own a business now have created a partnership between themselves. And if you just have this called a general partnership, if you just have this general partnership, just like with a sole proprietorship, the partners are liable. You share responsibilities, you're liable for the business debts, and any type of suits, the same thing as a sole proprietor, you are liable. And a lot of times, individuals don't even realize they're establishing a partnership. It's the same thing with a sole proprietorship. They just think I offer this. They didn't know they actually establish a legal responsibility, but you do. You establish one. But here in Georgia specifically, state by state, the type of entities that you can form may be different. They pretty much mirror each other, but there can be some slight differences where one state doesn't offer a certain type of entity structure and another state does. Speaking specifically for Georgia, right? So if you have a partnership and you say, I don't want to be liable, personally liable, meaning personally on the hook for paying whatever it is that you need to pay, fixing whatever it is that you need to fix if someone claims some type of injury or damage. If you do not want to be personally liable, then in Georgia, right, you can go from a general partnership, we just talked about, where you're sharing management responsibilities and liabilities and debts, to a limited partnership. And a limited partnership can be formed by two or more people, right? You have to have two or more people. You have to have two at least to form a partnership. But you have a limited partner where it's two more people and, at least one general partner in that partnership. And then the other partner could just be a limited partner. The general partner, however, will be responsible and, liable for the management of the company and everything else, where the limited partners are limited in their liability and more than likely won't have any involvement in management unless specified in a partnership agreement. And there's different times where that would make sense, right? There's different times where you may have some joint ventures or investors who may want to form a partnership, but don't necessarily want management responsibilities, but they want the membership benefits and they want a general partner that's managing everything. And again, I'm not going to go too deep, but for clarity, if you had a limited partnership, and I said that you have this general partner and then you have the limited partners, for that general partner, if you say, okay, well, I don't want to be personally liable for anything that happened, a general partner doesn't have to be an individual. It can be another business entity. So within that business entity, it's shielding whoever, are members or shareholders of that business entity. But there's times where limited partnership makes more sense. You want protections for certain individuals and you want them to have limited involvement in management while you have a general partner. Then we also have in Georgia, all right, so you have to ask yourself again, what are my goals, what I'm trying to attain? Limited liability partnership. And this is a type of partnership that allows partners to limit their liability. So this goes back to the partnership I talked about. General partnership, if you just start a partnership, you do not establish an entity. It's the same thing as a sole proprietorship. Except for the sole proprietorship, you have one individual who's completely on the hook. Partnership, you have two or more individuals that's completely on the hook. But you may say, okay, I don't want to be on the hook in this partnership. Now in Georgia, you can form. Now we're going from just running and going to the Secretary of State. You can form a limited partnership or a limited liability partnership and limit your liability in a limited liability partnership for the partnership debts and obligations. So that's what I want you to think about when it comes to partnership. And look more into those type of entities to see what are the other pros and cons of saying, I just want to step into this versus an LLC. I'm going to talk about an LLC just in a second. But why would I want a limited liability partnership or a limited partnership versus an LLC within this partnership engagement? And there are plenty of reasons why you may want that while still shielding yourself from personal liability or limiting that personal liability. All right, another entity, right? You have to ask yourself, is a corporation a better fit for me? A corporation is a separate legal entity from its owners or the shareholders. It's totally separate. So remember, we talked about the sole proprietor and a partner, that you're one and the same. When you start looking at the corporation, you are separate. Same thing with the limited liability partnership and a limited partnership. You are separate from the legal entity, is distinct. You are not personally liable for any of the corporation debts and obligations. But with a corporation, now that we talked about, being shielded, there's some other things to think about. By default, right? If you form a corporation, by default, you are taxed as a C Corp, which just means you will pay double taxes at the business entity level and then what you actually get. But a corporation, for some individuals, say that may be my goal because I see myself just growing huge, going big. I see myself going public, right? There's companies out there that eventually go public and get people to buy shares and come in. You just know that's where you're going. And a corporation makes more sense for you to do that. So I want to touch on this really quickly because I see this a lot more often than I would like on social media. But I want to educate you on this so then when you see it, I'm sure you had to run across it. This thing about S corporation. So like I said, when you form a corporation, by default, it's taxed as a C Corp. You pay taxes, a double taxation, 2 levels, corporate income, shareholder dividends. But for some individuals say, I want a corporation, but I do not want to be faced with that double taxation. You can elect to have an S corporation. And so you may have heard a lot of times people talk about S corporation. And if it's an S corporation, this allows for, what's called pass-through income. Your entity now becomes a pass-through entity, and you don't have to worry about the double taxation. However, with the S corporation, there are some limitations. There are some things you have to think about. When you elect X corporation, there's some do's and some don'ts. And if you don't understand those do's and don'ts, then you could lose your election, your S corporation election, and you could lose that for 5 years. You can't get it again. So although it has its tax benefits and some other benefits for it, you have to still ask yourself, what are my goals? Right? Just to give you an example, have an S corporation, you can't have more than 100 shareholders. Do you see, because you chose corporation, do you see yourself going so big that you may want more than 100 shareholders? Well, you can't have more than 100 shareholders if you elect S corporation. And if you have shareholders who can either be individuals, it could be an estate, it could be certain type of trust, tax exempt organizations, whatever. It must be that shareholder, however it's established, or if it's an individual, must be a U.S. citizen or residents. Can't be foreign. So you have to ask yourself, will you have shareholders, investors, or anybody that may be non-U.S. citizens or residents? Is that something that's part of your goal? If it is, elect an S corporation wouldn't be the move, right? And then you only can have one class of stock. And it goes on. And you have to go look at all these things. But when you assign different classes of stock, especially in a corporation, you might sign, A class, where these people that have A class stocks have voting rights. People that have B do not. They have something else. And that's how stocks are used to kind of move around. But if you elect for X corporation, you only have one class. So these are questions to ask as you just hear people throw things around and you hear the benefits of things. You have to then ask yourself, is this business entity or structure matching my goal? I hear the great things, but what are the limitations, and see if it matches. And furthermore, before I move on to the last entity, there's two things to think about when you're asking yourself, what type of business entity to form or structure. Please know you need to understand the type of business entity to structure, but you also can have a tax structure. Tax treatment can be totally different than entity structure. So like with the limit liability company I want to talk about, right? The limit liability company, the LLC, is the most flexible, the most well-known. Everyone talks about it. Everyone throws it out. And I'm sure a lot of people just go and form it before asking themselves that question. Is this entity the best thing for my goal? They just form it because LLC may be synonymous with just having a business to most people. They don't think about all the different type of entity structures and what may match their goal. But a limited liability company is that hybrid. It's an entity that combines having that liability protection that we talked about, like a corporation, but it's very flexible, right? And its operation, very flexible. The corporation, you have to make sure that it's high governance. You have to have, your board of directors. You have to make sure you have your bylaws. You have to make sure you have all the things in place. With the LLC, you don't have to have those things, but I will tell people this. And if you go to my YouTube channel, I have a whole 7-part series where I break down an LLC. And I tell people this, even with the flexibility of being able to establish an LLC, do not get so caught up in flexibility that you compromise formality. Because what we see on this and in the court is that the court says, yes, you weren't required to do these things. Yes, you didn't have to show us you did these things. But when an issue arises and you don't have those things in place, those very things are the things you needed to protect you. So although it's very flexible, it's the youngest entity. They're still figuring out in the court system how to handle certain issues. And I strongly advise, don't be that, person that is getting figured out with the new laws. Don't be the guinea pig. So don't compromise formality for flexibility. Be very careful of that. So I would say mimic a corporation. right? You need an operating agreement. Just like you need a bylaws for corporation, you need your operating agreement. And although no one's really checking that, you need to have that, because at the end of the day, if you do not have that operating agreement in place, there is an agreement that you are actually being governed by. And that's called the Limited Liability Company Act. Here in Georgia, it's the LLCA, and other states have their versions of it. If you don't have an operating agreement in place, when something goes wrong, they go to the statute and they'll tell you how those issues will be handled. So create your operating agreement just like you would for the corporation bylaws. But going to what I said before, business entity structure versus tax treatment, it's like with an LLC. You could say, okay, by default, if you are a single, sole owner, by default, you form a LLC. It's treated as a separate legal entity, but it's treated as a pass-through entity, just like we talked about with the sole proprietorship. If you were just single, you're taxed the same. The difference is, with a limited liability company, it still treats you as a separate entity when it comes to liability. But pass-through tax-wise, it treats you as one and the same. But you can choose, no, as an LLC, I want to be taxed as a corporation. As an LLC, I want to be taxed as a partnership. You have a partner. So you have flexibility on choosing the type of tax treatment versus choosing the type of entity. So ask yourself that question. Does the entity that I have serve the goals that I want, where I see myself going? Also ask yourself, am I just forming this, because this is a common mistake? Am I just forming this because I'm copying someone else's setup without knowing the why? So just know, asking yourself that question and answering that question will definitely impact your taxes, your liability, and your growth. And be very careful of just hearing, again, what individuals are saying they have or what they say you need to do before they even know your particular situation. You definitely need to make sure, especially when it comes to the S corporation, there are so many different benefits and there's times to move that way. But you have to know the restrictions of it to make sure you don't violate those before you decide to elect S corporation for whatever entity. All right. Let me see. Let's see, Deborah. So if you don't have one, an agreement will be placed upon you, whether you like terms or not. Mm-hmm. Yes, absolutely. Absolutely correct. So Deborah reiterated, if you do not have an operating agreement, there is already what's called an LLCA, the Limited Liability Company Act, here in Georgia. That statute is very similar state by state by state. See what yours is called, but you have a statute and it's going to govern your LLC. And it has we have to read stacks. I read the whole stack. It have any issues that you could think of, it's covered in there. And if you run into an issue, either with partners in your LLC or someone who just did business with you, if you run into this issue, the court will first say, give me your operating agreement that speaks to how you handle these type of issues. And the court respects that agreement because it is a legal entity. And what do we respect in America? Contract. You have contract law. And because the court knows that you and your entity are not one and the same, even if it's one of you, I want you to hear this all, even if it's just you have to know your LLC and you are not one and the same. So when you do an agreement, operating agreement, you're signing that operating agreement as a capacity of you as a member of your LLC. And so the court will look at, here's your operating agreement, and this is how you say will be handled. Then this is how we're going to deal with that. If you don't have it, they're going to go to section 2.5A, I and say, this is how we're going to handle this issue, because you have an agreement. You just have to choose which one you actually want to be governed by. So operating agreement is important. And that's why I'm here to talk to you all. Because when I say the reason why I picked these top questions, please know these are the top things I'm seeing. I'm feeding you because these are the top things. These 7 questions is not it, but these 7 questions are the pillar. Like, they're the foundation, they're the top. This is what's catching people and hitting them hard. All right. So the next question you need to ask yourself is, do I need a license or permit? A lot of times we get up and running. We say, okay, I established my entity, let's go. And we forget about that important part that a business license is generally required to run a business. Again, I'm going to focus more on in Georgia. This is where I'm located, but please check everywhere you're at. It's the same. I mean, all states are mirroring each other with slight differences. A business license is generally required to run a business in Georgia. And most businesses that are operating in Georgia, they must obtain a business license, your county and/or city, and it could be your local municipalities or subdivisions. Sometimes people get this one license. You have to make sure the business you're running, what obligations do you have and to whom? What licenses you need? And licenses may be totally different than permit, right? You may be running specific trades, professions that you may need permits as well. So you have the business license, and you want to make sure you are reviewing your local ordinance to ensure that you're in compliance to having the business license that you need. It is, unlawful to operate certain businesses without business licenses, especially, let's just say, food establishments, right? Without obtaining it. And you may have some people that feel like, I'm not this big restaurant. Well, if you're established enough where you have food sales and it's a food sales establishment, you're not supposed to be operating without a license from the Commissioner of Agriculture. You have to read to see what those requirements are to see if you are exempt. And while I'm talking about this, I do want to say quickly, because this is a common thing, right? Because again, a lot of us are sole owners, sole entrepreneurs, and we are just on the go. We're just trying to do it. When we're talking about business license and running a business, you have to be very careful about the business being at your home and you live in an apartment complex, right? So we got to talk about, one, can the type of business that you want to run, is it zoned for you to run that business in that area? But more importantly, if you live in an apartment complex, can you be running your own business in an apartment complex that you don't own? That becomes an issue, right? You want to definitely check your leases, but even if it's not in there, if you find out legally that you're not supposed to do it, when an issue arises and you have your apartment complex as the principal place of business, there's a big problem when you're talking about running a company. So I wanted to make sure I pull that out, because that is a common thing, right? So it's not just about, like, when you register your business, we talked about earlier, registering your entity. A lot of times you have individuals that put their home address. That's one issue, right? But more bigger than your home address being on Front Street, it's, are you even supposed to be using that home address if you don't own that home? And if you own that home, is your area zoned for the type of business that you actually attached to that address? So here in Georgia, they're really big on it. I'm just talking about even a few cases just to give you an idea what goes on in this court system. So you may have some exemptions of when you don't have to get a business license, I mentioned earlier. But what I want you to do is really be knowledgeable about, one, what those exemptions are. Two, how do you qualify for it? Georgia court here has held and have convicted individuals who said that they were exempted from having a business license. There's a particular case where there was this disabled veteran who believed that the requirement for having a business license for the business that he ran, he was exempted. And the court here in Georgia found that that disabled veteran, that business owner, failed to meet the requirements for the license. So although he said I'm a disabled veteran and all the things listed, there were particular paperwork, particular things, particular language that had to be submitted to say you fit this exemption. Not that you're just disabled, but you fit it. This disabled veteran even had, expert witnesses as doctors, and because they weren't corroborating on certain levels of issues, saying that he was good to do this or that, then in the totality, the court said, no, you failed to meet the requirement of the exemptions. So I want to let you know, whatever you think your situation is, you could be looking at yourself, look at the situation, say, okay, I'm exempted. Make sure you're reading what you actually have to meet in order to be considered exempted by the state, not by you. Also, I want to bring up in the court, some people may say, oh, this is a small thing, right? I'm not doing anything major or big. Well, let me tell you how Georgia courts look. They have convicted business owners who are operating home improvement business without a license. I'm talking about things from like just, uh, paintings and all this extra stuff, right? Home improvements. And they didn't have a business license to do it. They thought what they were doing was small. And they said, no, home improvements require a business license and you need to have a license. Um, we have someone that was in Georgia that qualified as a dealer under the Georgia Dealers in Agriculture Products that did not have a business license dealing in that realm. And you know what the court did here in Georgia to that particular defendant? All of the contracts that business owner entered into could not recover under those contracts because it was related to doing and entering into contracts as unlicensed business activities. So this is why it's very important to pay attention, because if something was to happen and someone want to come back after you, and we're talking about contract issues or whatever it is, and I'm going to tell you what attorneys do, right? You're here. I'm giving you the nuggets. We have to drill down and look at all the things. These are some of the things we're going to check off to see if we can help our client prevail, if we on one end, or help our client, excel on the other. We're going to look at these things. Oh, this person in this contract, okay, did they have a business license? Do they need a business license? These are the things that we're going to ask. So you have to ask yourself to make sure that you're fully protected. You can move forward, do what I do, require a business license. All right. Question 3. This one, like I said, can take up so much time. But I cannot do it, of course. But this is a very important one. I should probably put it as my last question. But Deborah said, yay for that crackdown on home improvement companies. Home improvement is one of the highest. Yes. One of the highest fraud. Yeah. And there was a big one, Deborah, in California as well. It was a group of them that was doing all this home improvement, and it was contractors and everybody, they didn't have the business license that they were supposed to have. And those individuals, it was 12 individuals, they actually got jail time and got fines. So you're right. That's the thing. It's the crackdown, to your point. So question 3. Let's see, I'm put this up. Question 3. How can I protect my brand legally from the start? And I phrase that question that way because I know that's how, one, I'm speaking to startups, but 2, even those that's running a business, we have to rewind because we had to think about, how do I protect my brand legally just from the start? Intellectual property is the first thing that should come to your mind. And for those who don't know, because I'm not going to speak over people's head and I'm not going to assume, your intellectual property, your IP, is those intangible things that makes tangible money for you. So I may make a particular product that you can touch. I may provide a service that you feel I'm benefiting from, but that intellectual property is that thing you don't actually necessarily touch or feel, but you associate with whatever gain you have. So, trademark, right? So, a trademark can be your name, your business name, your logo, your slogan, all of that. Copyright. If I'm a content creator and I'm creating all of this content, that is my copyright. I own a copyright to that. This podcast I'm doing right now, I copyrighted that. Like my stuff, I copyright that. You can't touch what I'm doing, but I'm curating it. I'm recording it. I do all the things. I copyright that. So if you want to protect your brand, your company, your thing legally from the start, you have to think about intellectual property. I'm going to tell you something. Those who understand business, I'm talking about, because I know if we're doing this, right, we're doing it with the thoughts of, I don't care how high you're trying to go. That's your personal preference, but we're doing it with the thought of being excellent. And those who are actually doing it like that, these are things that they're talking about and thinking about. If you want to even have a conversation with someone to take it seriously, that are decision makers that you want to connect with, I promise you they're looking at this. So this should be the first and last question. How can I protect my brand legally from the start? It's not just about protection, it's also about perception. So we're talking about branding from a protection aspect, but we're also talking about a perception. Your reputation precedes you. And I want you to know that registering an LLC or an entity that we talked about earlier is not the same thing as a trademark. I bring that up because a lot of us are confused with that. I already registered my business. So I have a federally protected trademark. There are levels of trademark. So I'm going to bring it down. I'm going to slow it a little bit. I'm not going to go deep because I don't want to confuse you. If I have my company name and I already go out there and I use my company name, okay, tracking with me, I have common law rights and a trademark. Once I start using it, it's the same thing as copyright. If I create content and I put it out there, I created a copyright. So you say, Lakeisha, then why are we talking about the protection of it? Common law is the lowest protection. Yes, you can at times have someone who have strong common law rights. If I had a trademark and I never federally protected it, or I never registered it with the state, but I was just out there operating and I did it for 20 years, and someone brand new comes and they have this my trademark and they try to register it, if I find out, yes, I have strong common law rights to fight them. But I will tell you this, and this is when we're talking about our court system. It is as unpredictable as the weather is right now in Georgia. You go to court, it depends on the judge you have, the day you have the judge, how they feel about who's representing you. It's not as consistent. And yes, as attorneys, we do use what's called precedent. We try to find law to back up whatever our argument is, but we have the other side is trying to find law to back up theirs too, right? That's what we're both trained in. How the jury or the judge falls may not be in your favor. So yes, you have common law rights. Yes, you have a common law trademark. But you start stepping up the ladder as you register it. So that's why I say a LLC is not necessarily giving you federal protection, right? At all. It's not giving you that at all. But it may give you common law rights and a trademark name. It kind of shows that I've been operating. It's kind of like a paper trail at least, but it's not giving you the security that you want as a true business owner. You want to make sure that you are checking to see if the name is even legally available. That's important for us. And a lot of times we are creatives. We are creators. And we'll think, oh, this idea was mine. And then we find out something out there is either same or similar. So we have to check to see if this stuff is actually legally available for us to use it. The same way I just gave the example for you, right? With the common law. and you want to protect your common law rights, you got to think about it on the flip side. Maybe somebody was operating common law and didn't federally protect it, but they may be out there. You don't even if you don't want to deal with the argument. So just you're checking with it, the USPTO, you're looking at the Secretary of State, you're looking at everything just to see if it's legally available. And why are we doing this? Why are we stepping it up? Why do we say, okay, I have a trademark, I have this name, this logo, whatever it is. It could be sound, slogan. Why do I want to now register it? Because the value of your content, your products, your systems, all your original works, it goes up. Something called valuation. We're constantly working to produce products and services, right? That's our labor. We're putting labor into that. We hire labor for that. But when we want our thing to work for us without working, that's called valuation and adding value. So now there's certain requirements or criteria that you must meet in order to federally protect a trademark. If you don't meet that criteria, you can still protect it on the state level. So I always still say, come out of common law, go to state. If that's all that, the highest you can go, at least go to state. But if you can go higher, federally go. And you're building valuation. So it's talking about protection and we're talking about perception. I tell people filing is not an option. It just is not. It is crucial for businesses, like I said, for the legal protection, but just for your brand identity. Just to be considered, playing the game, understanding the rules. People are already judging if you understand the rules or don't understand the rules, if you're legitimate or not legitimate. They're already judging that. I'm telling you, I'm giving it to you. I'm coming out of the room and I'm coming out here to let you know. Because I don't want anyone talking about anybody in these rooms. I want you to know. Okay, Reese says, does it make a difference if there is a business name in the same or different state? Yes, it does. So, and I'm happy you asked that question, Ree, because that helped me hammer in the point I was making about LLC. Thank you. And see, this is why I want you to ask questions, because it helps me too. Remember I said the LLC is not, definitely is not federal protection for trademark. It shows you have common law possibly, but you can register the same names in different states when you're talking about the Secretary of State. When you check to see if a business name is available in Georgia, you can't do that here in Georgia. But we can have same business names all over. Trademark, however, when you're now going out of it and say, I'm federally protecting my trademark, and if you show that you was in existence first, this other name, that's where the cease and desist letters come in at. That's when you can shut it down. That's how you can even shut down a whole nother LLC or corporation, if that is their name. Forget a logo or this. If you register, federally protect your trademark, you can cease and desist other people. You see how that even have more power than the LLC formation? Now, let's take out the federal. If we're talking about, everybody said it's different levels, state. No. So common law is just that geographical area in which you sell your products or service. When you register in a state, it's helping protect you in those states or state that you register, right? So you have to go register 50 different places in order to expand that reach. When you federally register, it protects you in all U.S. states. You knock it all out. If you're able to do that, because there is criteria again to register for federal protection versus state. And just to quickly give you an example, if I am a lawn care service, I guess, and I'm established here in Georgia, and this is where I offer my lawn care, and I don't offer it in any other state but Georgia, I will not qualify to register my federally protect my trademark, because you have to enter into what's called interstate commerce. And all that means is that you have to sell your product or service outside of more than one state. Once you cross that one border, then you can federally protect. That can be online as well. So if you are established in Georgia and you offer services, sell products, and people can order online from other states, you are now in interstate commerce and you also qualify. But if I'm physically doing lawn care, I'm not showing up anywhere in any other state, I don't have any independent contractors, I don't have anything, I can only protect it in Georgia, which means other people can have that name too. Good question. So that is very important with the federal trademark. And just to give you an example, I try to include some examples in here to kind of one, help it hit home, but two, to show you that it's not a small group that don't understand this stuff. I see it on all levels because you only know what you know, and you don't find out you don't know until you find out you didn't know. And so there was a situation, I don't know if you all heard about the Katy Perry situation, where there was this fashion designer who birth name was Katy Perry, but it was, you had Katie and you had Katy, and both last names the same, but was a fashion designer, sold clothes for under her trademark, and then Katy Perry sold merchandise during her 2014 Australia tour. And the other Katy was like, yeah, no. Cease and desist. You are infringing upon my trademark. I got it for this particular class. And the other Katy was just using it in good faith. I'm Katy Perry. I'm selling my stuff. Good faith, innocence, none of that mattered. It doesn't matter in the court. What matters is if you infringed. So Katy Perry had to pay damages to the other Katy. And she went by pseudonym Katie Taylor. So just the difference. Katy Perry had to pay Katie Taylor. So you see, you have somebody so big like that, right? So it's happening on all levels. So I'm here to empower you. So that's example. All right, question 4. Let me make sure I'm not missing any questions here before I move on to question 4. Oh, that makes sense. State versus federal. Yes. Good. Good. All right, Deborah, that's right. Protect brands with ELLAvation, trademark attorney. Absolutely. And I even have, because I know, with me even educating individuals, and at the end of the day, we got to find our way. If we decide to step in the game to play, you have to find a way to win at the game. So however it is, it is. But I do understand there may be financial constraints here and there with different people. Figure out how to make it happen. Put your head to it. How can I figure this out? How can I talk to this person or that person? And what I've done was I even created a course, right? So I try to do different levels. I have books where I give information. So you're not at the $20 level. I have a course that literally, so you're investing your time. You may reduce on money, but what I pushed you to do, you have to invest on time because I give it all. You sit down, it's an online course, and you sit there, and it's literally teaching you how to do clearance search, which you'll see why it's so hard for us and why we charge money, but I'm teaching you how to do it. You do clearance search. The application's not hard, y'all. I'm going to be very, very, very frank with you. That application's not hard. I could teach 10-year-old whatever. That's not it. That's not what people get hung up. It's that clearance search and understanding how to do it properly within the USPTO, because there's things in the USPTO where you may say, I don't have this, but it could be the same or similar. Also, you have examining attorneys. Back to the point I made with judges, you don't know who you're going to get on what day, what they felt like. The examining attorney's the same way. You're human. So you may deal with somebody that's like, ugh. So that's where it becomes crazy. But I have a course that helps you understand what an office action is, that helps you understand clearance search and application, all the good things. So, but we're going to figure out a way. I'm giving you these questions and answers. You're going to figure it out. All right. What contracts, this is question 4. What contracts do I need in place from day one? You all could be able to, if you were here earlier when I talked about entity formation and documents that's important, you should already know two of those contracts, right? So you already, if you have a business entity, day one, you need an operating agreement. If you have a partnership, you need a partnership agreement. If you have a corporation, you need bylaws. Remember, as you're starting from day one, you're telling people, I'm about my business. And if you're about your business, the first thing you start with being about your business is with your business. You let your entity know, I'm not here to play games. Let's make this agreement between us. I'm literally, it probably sound crazy. I want you to treat it like this. Don't, oh, this is my baby, my company, no. This is a business transaction between you and your entity. And it's you're going to find out real quickly why this is very important for you to take this stance. You get that operating agreement. This is how I'm doing it. This is how I'm doing it. Okay, here. You're here to protect me. You're here to shield me on this. This is how you're going to shield me on that. This is how I feel about that. And the agreement's here to listen to whatever you say do. That's the beautiful thing. You're not negotiating with the agreement. Only time you negotiate if you have partners and all that stuff. But you put that down and you're telling that agreement how it's going to work for you. And when you sign it, you're going to sign it in the capacity in which you are operating under. You're not going to sign your operating agreement as you. You're going to sign you, and underneath you're going to put member. You're going to, and everything you do, you're showing I'm keeping us separate. I'm signing as a member, not just you, between you and the company, or I'm signing as a partner, or I'm signing as CEO, whatever your, title is. So what's the very first from the start? Day one, operating agreement, partnership agreement, bylaws. And if you don't have any of those in place, go back. Your day one starts now, even if you're up and running. Go and do it. You want to make sure that you have client agreements in place, service contracts in place, especially with that, because we talked about what? Intellectual property. You want to make sure you're very clear. Those who, like I said, moving all the way up, I don't care what contract you get. You'll think, why is this IP provision here? Because it's going to be, and everything you throw now, make sure you know I have intellectual property and it's mine. Whatever we're doing here doesn't touch that. So you want service contracts in place, independent contractor terms in place. I'm going to talk about that a little bit in another question, because this is really important. This is what a lot of people miss, but a lot of us are in a courtroom on this point. I'm going to make later. But so client agreements, service contracts, independent contractor agreements. And when you have these contracts, right? So not only what contracts do I need to have in place from day one, you need to understand certain things. There's things that may change in your contract based on negotiations, right? There's certain price, time, all that stuff. But what you really need to understand from day one, do you need to be covered, protected, indemnified is what we call indemnity. If someone does something for you, but put your company on the hook, they have to indemnify you. That means they have to, if you are found liable, on the hook, in trouble, whatever you're found liable, on the hook, or in trouble for, they got to cover it. That's something you have to make sure that you have near day one. A jurisdiction, this is completely overlooked. What jurisdiction is governing your issues? You want it to be somewhere where it's convenient for you. So what contracts in place day one and what terms are there? And then, of course, termination. Like, when does this end? How does this end? And I'm going to tell you why that's important too. I brought those three things up because those 3 things that get people in trouble, 3 things that are overlooked. And I want to say this. While we're saying contracts in place day one, y'all still with me? Come on, try it. This is important. I'm giving it to you. Listen. Verbal deals lead to legal disasters. Yes, is it true? And we've probably heard it before. You don't have to be written. There's verbal deals are, honored. Yeah, they are. That can go back to the argument we talk about what judge you're going to get, what day, what jury. But more importantly, what people are not talking about, and I want you to understand this, to answer this question, what contracts I need to have in place, verbal deals are exempted from certain contracts. It cannot be a verbal deal. It's something that's called statute of frauds. If this type of transaction fall within that statute of frauds, it has to be in writing. So when you're asking yourself question number 4, what contracts do I need in place from day one? I need any contract that falls within the statute of frauds. You got your pen, you got your paper? I'm going to give you an acronym that we learned as attorneys to help us remember. The acronym is MY legs. M is for marriage. What I'm about to give to you now are the type of contracts to be legally enforceable. Now, don't get me wrong, you could do whatever you want to do. You don't have to have it written. What I'm talking to you about as a business owner, and with this question, what contracts do I need in place? What contracts you need in place in order for whatever that agreement to be legally enforceable? Okay, you there with me now? All right, statute of frauds. Marriage, that's M. If the service is going to be a year or longer, that's the Y. If I enter into an agreement for me to provide a service for someone, and the anticipation is it's going to take me a year or longer to finish that service, provide that service, it has to be in writing. So you got marriage, if it's year or longer, so that's my. And then if it's land, if you're entering into agreement and it has to do with land, it has to be in writing. It needs to be in writing. If you have an executor agreement, guarantor agreement, if you want somebody to guarantee something as a guarantor and you just talked about that, so bad, so sad. Sign someone executor, you just talked about that, so bad, so sad. It has to be in writing. So you had MY. Now we're on the L, land, E, executor. And then we talked about guarantor, G. Now the last one, sale of $500 or more. I'm not going to get into this now. There's another segment I did. I want you to go back and look at it about contracts. This is what people don't know. We talk about contracts as like this bucket thing. Legally, there's different types of contract law. You have the contract law for services, and then you have a contract law for sales of, products that's under the UCC. Those are different types of contracts, and different things are required for those different types of contracts. So there's a lot of people out here that's selling product. And a lot of people that are selling product, even if they're trying to do the best thing, may have some kind of contractual language or these things, may not be meeting the threshold of what the UCC say you have to do. And that's the Uniform Commercial Code. If you're selling products, that's different than a service. It's totally different. But go listen to that video. It's a contracting video. I can't think of the title of the name of my top of my head, but go listen to that. I break it completely down. So that's important. So verbal agreements are, scrutinized under the law. They really are. Even when they tell you, oh, you don't have to, you can have some legally. You now know my legs. As a business owner, if you fall in my legs, it's going to have to be in writing, period. It was crucial, Tony. Oh, thank you, Deborah. Yes. Contracts. Yes. Contract agreements. Okay. Let me pull this up here. See, contract agreements, for example, service agreements, should they be drawn up by an attorney, or can you create your own from samples on Google? You know what, Ree? I should just pull you on a stage, but this is a good question, right? So, I'm going to start with, of course, yes, it should be drawn up by an attorney, not just an attorney that's familiar with whatever you're talking about, right? So you're not going to go get a family law attorney to draw up whatever. So I'm going to say that. Be very, very careful with that. The ESQ, Make sure it's right. So, yes, I'm going to say yes. But can you, create your own, from samples on Google, Chat GPT, because that's where we at and stuff now? Yes, you can. However, and I'm going to talk about this in another segment because this is how bad it is, y'all. It's not just bad for y'all. It is some stuff going on with us attorneys who is using Chat GPT, and people are getting disbarred because it was uh, bringing back inflated citing to cases. Got to remember, AI is still artificial. That depends on human intelligence and manipulation. AI is great and it's quick, but you have the human quality behind that. And when we don't do our checks and balances, I am big for that. Yes, the AI helps. It is an assistive tool. I use it as an assistive tool, but it will never become the thing. And this is where not just the layman and laywomen, but attorneys are catching it. Trusted this AI, you didn't do your check, you didn't do your balance. AI only feeds off what everybody's talking about. It starts to memorize different things. It's thinking it's pulling the right thing, but it may not be pulling the right thing for the situation, citing wrong cases or inflating the case that it actually cites. And in our case, where we can get in trouble is, there's this thing where you can't, the unlawful practice of law. Just like if we have people work for us, we have to supervise and manage them to make sure no one, yes, the hallucinations, that is it. We have to make sure that no one, crosses the line from assisting us to actually practicing the law. So what happens is, what the legal world is talking about, specifically Georgia, I just learned, I attended one of our CLEs, the Georgia State Bar has created, they have a, what do you call that? A group, a board. They put together a committee that's figuring out how to deal with this. That's how serious it is. You don't want to go from this was supposed to assist me to now there's unlawful practice of law. You don't want to go there, because just like if I had a human person and they could only assist me and I have to reel certain things in, it's the same thing about the computer. Now they're trying to look at, can we violate our rule of ethics for that unlawful practice with AI if we don't do our checks and balances? And they're clearly seeing where we're not doing our checks and balances with those hallucinations, as Deborah's talking about. So imagine a layman. You thought you got it for sure. It sound good. Oh, this was it. But something in there may be inflated. It may not even apply to your situation. It may pull you into another jurisdiction. It may protect something for someone else that you thought, okay, but maybe I should have did it this way. My famous phrase is, it's not what's in this thing you see. It's not what's in the contract. It's what's not in it. You may have it put something in it, or it may put something in it without making sure this other thing need to be in it to balance that or to help you. So that's what I mean by yes and no. So yes, of course, getting a competent attorney to do the thing that you need. And yeah, of course, you can Google Chat GPT and all that. But at the same time, you have to make sure that what you actually got, it doesn't just sound good. It's actually doing the thing that you needed to do, which is protect you. So absolutely. And if anything, I tell some people, shoot, talk to some attorneys, maybe to help you. Maybe instead of having a contract draft, right? So you may say, instead of me paying for a contract draft, can I pay for a contract review? So now you started somewhere, and maybe the fees may look different for a contract review versus a contract draft. So there's ways to play with the tools and resources you have, play with it. But I would say, don't just walk away with it, because if we're in a buttload of trouble, I can only imagine. And then imagine one more thing before I move on. Imagine if you go to in the Reuters case, fake cases were cited. Right. Let me put this up here. Let's see the Reuters case. Imagine how, if I was a litigator, because this is how I think. So even though I don't like going to court and do not litigating, As a transactional attorney, I study the heck out of cases. That's how it helps me to make my argument even in contracts, because I believe we litigate in the contract. So what I will use, I'm going to be able to tell if you use ChatGPT based on certain things, based on how the language is, certain thing. And then I will say, oh, but we signed this and you was the one who curated it. And you were the one who said, I'm going to accept this document from an instrument that unlawfully practiced law. Now, I will either see how that will work for me. Either I'm going to get out of a contract or I'm going to get damages from you. There's things that we're looking at too. So just know, yeah, make sure you pay attention to that when you're Googling anything or you're using Chat GPT. But I'm going to do a segment on that because I've seen some people talk about, AI is going to replace certain jobs. And legal was one. I said, oh, no. They replace certain jobs. They're going to be hiring a lot more judges. It doesn't work that way. All right, question 5. What are the requirements, and this is really overlooked, for foreign businesses operating in Georgia, right? So you will have some individuals that, or even, I'm going to say in Georgia because I'm here, but this question, just take it as, what are the requirements for foreign business to operate in another state? It is important because sometimes we'll have our business and we'll be operating interstate commerce I told you about in another state to where it actually falls within their legal explanation of transacting business here. There are things that are exempted because they want us to operate interstate commerce. So there's a lot of exemptions. The reason why I bring this question is because I just need you to know, because some people have been confused on this. I need you to know, I completely fall in the exemption, right? I'm here, in Georgia. People order my products here from Georgia, but I may be transacting with people in other states. That's exempted. You can even have someone who have a business that's in another state, say it's in Florida. All the products are in Florida, but they're in Georgia. They have people operating for them in Florida, but someone calls them in Georgia to get products. You get the product shipped from Florida to Georgia and distribute the products in Georgia. That's still exempt. So there's the details of it. I don't want to confuse you. I just want you to think about that to make sure what I do if I'm crossing state lines, am I actually considered transacting business in this other state? And the reason why I say that is if you don't know that answer and you're not obtaining the certificate of authority for your business to operate there, and that means substantially, there's different measurements they look at, right? So a foreign corporation or a business or entity, when I say corporation, I'm talking about it all. You must obtain a certificate of authority from the Secretary of State before transacting business in any state, but I'm going to speak of Georgia. And if you do not do that, without this certificate, you cannot maintain any legal proceeding, and that's in Georgia. So say I'm operating and you have an issue with someone, didn't pay you, didn't deliver, didn't do something. All these letters went back and forth, demand, they didn't do it. Now you're ready to I'm going to just take you to court. The court says, no, without the certificate of authority, and you was transacting business here, you cannot enter our court doors. You cannot do it. Now, yes, there's times the courts here in Georgia especially would say, you can't enter them, so we'll dismiss this. And what we call in the legal world is without prejudice, meaning if we dismiss something without prejudice, you have the opportunity to bring it back to court. If we dismiss it with prejudice, it's done. So a lot of times we'll say, we're going to dismiss this claim that you have without prejudice. We're going to give you a chance to go get the certificate of authority. So you may find out then, I never knew I need one. You can get it then, and then, you can bring whatever action in court. Now let's flip that. So remember, you need a certificate of authority as a business owner. Do I need one to make sure I'm protected? I could bring somebody to court. Okay, if I do, boom. Say if you did need one and you don't have one, and you are transacting business considered in Georgia, if someone else has an issue with you, they can bring you to court. That's under some totally jurisdiction, and the long arm statute is totally different. And people get that confused. You may not be able to raise a claim and maintain a claim, but someone can drag you into court. So you want to make sure that you're protected all the way around. Let me see. See the question come up. All right. You say, when you say foreign company, does that mean a non-US company? No. Okay, so let me back up. So to clarify, when we look at that certificate of authority for Secretary of State, I'm not just talking about foreign company outside. It could be that. I'm talking about each state. If you're not domiciled in that state, if you're not established, lived, built that entity in that state, and it was a different state, remember I gave the Florida, Georgia. If you come over to Georgia, you're considered the foreign company in that sense. It's state by state. So if I established an entity in Georgia and I'm operating by selling products or services, but I live in Florida, I established the business there, that's a foreign company. That's a foreign company. So it's not foreign, just foreign outside of the US. Nope, state by state. And again, let us not get confused. And I just gave you an example for Georgia. I can't speak for anybody else in other states who may be listening. Go check your stuff. But in Georgia, those are some things. And we have a non-exhaustive list of what is exempt. The way Georgia addressed it was, instead of listing what is transacting business, they did it from what's not. So if you felt uncomfortable for any reason, you could look at that. And remember, if for some reason later on, depending on the situation, you find out I should have gotten that, a lot of times the court will give you a chance to go get it and then come back to court if that is the case. But you can check the non-exhaustive list of what is not. And a lot of times what we're doing, like I said, you're selling cross lines. That's not a foreign company, but there's a lot of times that people are. They have substantial business transaction here. I did write a case somewhere. Okay, let me give you an example. Okay, here's this example. Hopefully this kind of ties it in a little bit. You had a general contractor that contracted with the Board of Education to construct 2 schools. And mind you, for those listening, this is a Georgia case I'm talking about. So for my Georgia people listening, the subcontractor was to supply steel on the project. And it in turn, because the subcontractor was going to supply steel, it contracted with the company to furnish certain structural steel. Now, the steel was refused by the engineers that was actually on the job. So you had the general contractor who contracted with the Board of Education, the subcontractor who's not in Georgia was just going to provide steel for the project. So it provided the steel. That steel was refused by the architect and engineer that was actually doing the job. So the subcontractor said, hey, we're a subcontractor for this general contractor. We said we're just going to provide steel. We're going to sue you for refusing it because it costs a lot. They lost a lot of money by refusing it and all that stuff. They supposed to have had the job. The counsel for the subcontractor argued this transaction, hear me now, was an exception under interstate commerce, because what the defendants try to say is, you can't sue us. You was transacting business in Georgia and you didn't have a certificate of authority. So you can't sue us anyways for rejecting the steel. The counsel for the subcontractor came and said, oh no, they didn't need a certificate of authority. They were just providing steel. So that falls under exception of interstate commerce, which is an exception, I told you, in Georgia. The courts looked at everything type of judge on the type of day. The court said, you were supposed to provide steel. You had the responsibility for the fabrication and delivery of this steel, the delivery of the shop drawing that was in reference of the construction, the delivery of that, of the 2 schools. You came to Georgia to do that. At the time the contract was signed for you to be a subcontractor, you came to Georgia to do that. When there was a meeting, you came to Georgia for that. And one of the engineers and a couple of your employees, some contractor, during the progress of the job, they came to just check out how things were performed. Because you did these extra things, it is not interstate commerce. It was substantial, and you were transacting business in Georgia. You need a certificate of authority to do that. So you cannot bring this to court. So I hope that kind of hammers that in, because I picked that one because it touches on all the points I made, where I said we are exempt with interstate commerce, but also you have to make sure you don't go out of, I was in exempt status, but I did these extra things that brought me into a substantial business transaction in Georgia status. All right. Question 6. What are the this is what you're asking yourself. Top 7. We're almost there. What are the employment laws and obligations I need to follow? This goes back up to the top. Remember I told you I'm gonna get to it. What I talked about, you need to have those agreements when you ask yourself, what contract should I have from the start? And one of those contracts I mentioned is independent contractor, because that's serious. When we're shaking hands and we're just telling people to do things, you can easily fall out of the independent contractor. I'm going to say IC definition to employee. That happened, there's a lot of issues that can happen. And when you're determining whether someone who is working for you, or not when you determine, I'm actually even say when Georgia determined, like you may say it's one thing, but when determining that here in Georgia, in the Georgia court, they're going to look at, should the person you hired been classified as an independent contractor, or should they have been classified by the employee laws based on several factors? And they're going to consider those several factors. And what we call it here legally is called the primary test. They're going to look at if whether you, as the business owner, had a right to control the time, the manner, and method in which they are providing whatever this service to you. Do you control that? Do you control the time, manner, and method? That's the basis where it starts. And if they determine that you, who said you hired this person as an independent contractor, retains that control, they're already going to lean to the side that this independent contractor is actually your employee. But if they're free to determine how the work is performed, and you only require specific results, then they're more likely an independent contractor. But they'll go further. They'll look to say, okay, I'm gonna look at some additional factors. First of all, what type of occupation is it? Is it a distinct occupation or not? What skills are required for the work? Whether you, as the owner, did you supply them tools and a workplace? How long was this relationship? And then this goes to the point I was making earlier. Is there a contract? Is there a contract in place? We talked about a year or longer, so that's already a big issue. Is this independent? Do you expect it to be longer than a year? But they look at if the contract is in place. And then they'll look at, did this contract establish an independent contractor relationship? And it shows that that you and them, your intent was to reflect that. But if they even look at that and say, yeah, there's a contract, It shows their intent was deflected. But with this primary test and this balancing act, still the method, manner, and means meant that you controlled everything, then they can actually be considered an employee. So they look at the totality of everything, but they focus on the degree of control. So please, as you're starting or currently running your business, if you deal with independent contractors, one, put in writing what the expectations are, but be very cognizant that you are not maintaining complete control to where you are now deemed to be an employer versus having an independent contractor relationship. Because if you don't, there's a lot of things that you may be on the hook for. If someone is an independent contractor and they do something to harm whoever you all are serving, then they need to have their insurances and need to have their things and stuff in place. But their employees, there's things that you expect to have in place to help them. There's all types of worker compensation. You're called what we say in the legal term, vicariously liable for their actions. So if they do something, you did it. Independent contractor, if they did something, they did it. But if you move to that employee, they're able to slip into there. If they did something, you actually did it. You're vicariously liable. So please, if you deal with independent contractors or you're going to deal with independent contractors, ask yourself, what are the employment laws around me? How do I make sure I don't slip from an IC relationship to employer-employee relationship? This has happened very easily, and I see it a lot. Let me tell you why I see it a lot, because it goes back to the mindset I was telling you. This is my baby. I'm going to tell you you got to find a way to say, be very candid on your deliverables. That's how you protect yourself, right? When you're talking about what your deliverables are, the standard of those deliverables, what, sendbacks may be, you can find a way to get what you want without controlling the manner, method, and means of how to get it. I hope that makes sense. So you want to make sure you understand that balance, because if you don't, and there's a lot of cases where individuals, not just vicariously liable, a lot of them found out because they probably consulted an attorney, more than likely. Oh, I could be asking for this. Oh, because they look at the pay, how you're paying them too. Oh, this rate. Oh, wait, I did overtime. They were supposed to give me overtime. They violated labor laws. So you don't want to slip into that employer-employee. So make sure, one, things are in writing. Don't go with the verbal. Forget the implied. Put it in writing. Show your intentions. But more importantly, because they look at the totality, make sure you're writing in there where you're relinquishing control, but you're expecting a certain type of deliverable. I hope that makes sense. All right. Number 7. We did the top 7. Hope you were tracking with me. This one. We talked about this whole time forming a business entity. And we know the reason why we form a business entity is, one, for protection. We want to protect our personal assets. A limited liability company, corporation, I don't care what you have, right? Whatever you have has its limitations too. So you have to ask yourself, and what you're doing especially, what liabilities and risks do I need to prepare for? And will this limited liability be enough? This corporate shield be enough? There's times where directors and officers are not covered. So you need to think about, do I need insurances? What we call the D&O insurance, director and officers liability insurance, to help protect directors and officers, agents of the corporation against liability for wrongful acts in their official capacity. Think about those insurances if that's what you have, a corporation. Would you possibly need a commercial general liability insurance? If you're running a business with a commercial business, to cover legal liability for any type of bodily injury, property damages that exceeds that limited protection. Do you have specialized business service that you're offering where you may need malpractice insurance? So you have to think, what I'm doing, is the protection of this entity enough to cover the liability? And then you have to ask yourself, well, when can I personally be sued, even with this business entity? And that's one of the reasons why you definitely want to make sure you have insurance. I'm going to give you an example. And I've heard people say this. Well, sue me. What are you going to get? Company don't have anything. And so let me back up a little bit too. When we talked about the company limited liability, if someone sues you, they're limited to the liability of that company. If it's a company transaction that caused the suit, they're limited to that. So that means they limit it to the assets there. And mind you, although we established this limited liability company or a corporation to protect it, we don't want people taking all of our assets either. Yes, you can, I'm not going to talk about it now, but you can have holding companies separate things so that way, if this company get in trouble, they can't get it. But they go into this company and they're trying to get all these things. And some people say, go ahead, go in a company, take what you want. You're not going to take anything. Doesn't matter. Go for it. Then I'll go start a new company. Can I tell you what the courts are doing? Can I tell you what the attorneys are doing? Yes, I could tell you because you're here. And this is why I wanted to end on this note, because this is very important. When a company has no assets to satisfy a judgment, the judge doesn't just look at, and definitely the attorneys don't just look at, well, they have nothing, so bad, so sad. These judges, attorneys, creditors, they're going to start exploring so many more ways to recover. They're going to look at so many remedies. They're going to look at, was whatever happened based on a fraudulent transfer? Like, did you move something knowing a lawsuit was coming? Did you have something and then you move it? It was a fraudulent transfer? Oh, they're going to get it all. That was the same. That's the thing with Cardi B and Tasha K. You move something when you're not supposed to. You cannot, even if you had the intention to already move something before a lawsuit, you had this intention. If it comes on a pipeline that you have a lawsuit or there's a potential lawsuit and you move it within that time of knowing or should have known, it's fraudulent transfer. So now they're going outside your LLC and going wherever you put that at. But this is the bigger one. Piercing the corporate veil. That's the easier one. For an attorney, I will go that way first and then reverse engineer it. I'm going to start with the piercing the corporate veil. Why would I start there? That's the easiest thing because we're not separating ourselves from our legal entity. So what we'll say is, how can I pierce this protective shield that this business owner have to make me just go into the business to now go into the business and everywhere else that they got? I want to pierce their veil. And that means if you are commingling money, if you are not separating yourself as a legal entity, you signing those contracts as you and not in the capacity or the authority of which you should be signing those contracts. If you are using company's money for personal debt, but you're not tracking it as if it's paying you, and that happens easy, right? Especially if you are a sole member, things move. So many ways that they would pierce that veil. That means they get to move the shield, move the company. They get whatever's in the company, and they're coming after you personally as well. Not just for the damages, compensatory is what we call it, the damages that happen or accrued from the thing that happened, but also for punitive damages. They're punishing you for the way that you operate, right? And so now when you say I don't have anything, they're going to get what you didn't have, what you do have, and what you may eventually have, which means that puts you in a place that if you say I have nothing, you will never be able to get anything, because every time and any time you get something, it is fulfilling a judgment. So now it's hurting you, your heirs, it's hurting until they actually can recoup. So if they move all that stuff out the way, then they're going to get you. So see, please don't go on an argument that I don't have anything anyway. We will find out. When I say we, I'm talking about the judicial system. I'm talking about attorneys. I'm talking about judges. I'm talking about even the creditors. How can I move this thing out the way? Because at some point they have something, and or they will get something. Otherwise, we wouldn't be business owners striving for it. And I'm going to make sure we have this thing over their head at all times until we recoup what we want to recoup. I'm going to give you an example of a case. There was an owner in Georgia of a nightclub, sole owner. You're sole owner. As I said, most of the issues come especially for sole owners or maybe, two partners of a nightclub who was held liable for an 18-year-old who left that nightclub and was intoxicated and was killed when she lost control of her car and struck a tree. Sole owner, struggling nightclub. I mean, I really don't have anything. I'm putting all my blood, sweat, and tears in this anyway. I don't, what are you going to get? I don't have anything. Okay, well, the jury pierced the corporate veil. And when they pierced the corporate veil, they found the nightclub owner jointly liable with the corporation. So it says if this corporation was to continue, one, we're going to get whatever we can from this corporation to fulfill this judgment. If we squeeze all that milk out, if you still run, we'll continue to get that, but you're jointly liable. Same thing with Tasha K and Cardi B. Because of the fraudulent, she became jointly liable. We're going to go for your personal assets as well for these compensatory and punitive damages. And the reason why they was able to pierce the corporate veil is because the court found that the nightclub owner commingled individual and corporate assets. So a lot of times we buy things and we don't separate, was this for the business or is this for me? I'm using my printer for me, but I say I'm using my printer for business. I'm using my car for me, but I'm using my car for business. We got to find a way to separate. And some people say, well, I can't get two cars. That's fine. Well, documentation. Show when this was actually when I'm using for business and this is when I'm using for not. Remember I said formality versus flexibility? Yeah, we don't have to document all this stuff until we have to document all this stuff. And so the nightclub owner commingled individual and corporate assets. The nightclub owner assumed the personal corporation's financial liabilities. And we do that, right? Because we're like, I'm funding my business. I'm assuming these financial liabilities. If I owe something from here, I'm paying it. But they're not paying it in a way where the business is handling that. I'm handling that for my business. They use corporate funds to directly pay mortgage notes and other expenses. So the court seen, yeah, this is a conduit for you, right? This business thing is a conduit, but you are literally one and the same, where the entity was supposed to separate you all. You're only one and the same for tax purposes, remember? But business entity wise, that was pierced. And so when that was pierced and the jury looked at it, the judge looked at it, everybody looked at it, creditors were happy, the court upheld the jury decision to pierce that corporate veil. And, where the business owner transferred those corporate assets, commingled the money, used the funds for personal purposes. So that's why you need to ask yourself for that last question. That's why I wanted to end there. That's where we really get hung up, especially when we think we don't have anything So I'm not going to sweat too much because I don't have anything anyway. I always tell people, you have something. You're born, you have something. And then you may have people behind you, and that judgment will hang over you until it's fulfilled. So ask yourself, what are my liability risks? Do I need to prepare for? Are there any extra assurances that I need? So if they come out of my LLC, it can be covered there. Or if I'm in my LLC, but this doesn't cover this situation. Those are the questions that you need to ask. All right. I want to make sure I didn't miss any questions. So that was it. I think I did an amazing job. My goal was to try to finish in an hour and a half. I just went 8 minutes over, and I'm gonna count that because I was addressing questions. And I want to make sure that I didn't miss any, because the questions are important, because it helps me to cover things that, I only know what to cover based on my experiences with things that have happened, with my knowledge. But you may have something that I was like, oh, didn't even think to, bring that one up. All right, this was oh, thank you. I'm gonna put both of you guys up. I will follow all the rules, keep minutes of my minutes. See, that's what I'm saying. Good job. Bring it up. Minutes of minutes, meeting of minutes. Make sure you have that. And it sounds crazy, right? I get it. And a lot of people say, it's just me. But remember, you are not your entity. And remember, I talk about protection and perception. When people start seeing that you're doing these things, it's like a different language. It's like you learned how to speak another language. No one's telling you that. They're paying attention to it, though. Are we speaking the same language, or does there need to be a translation? When you speak the same language as other people, you are looked at, it keeps going up. And so if it's just you do. I have calendars of stuff. I don't care if you had an ideal, you was running through things about your business, that's a meeting with your business. Notate that. Put the date. However you're doing that. Is it monthly, quarterly? What is it? Every 6 months? You just say, these are the things I thought about. The business is going to do this. I'm going to do this. You write what the meeting was about. You're meeting in your mind. You're meeting with your business, and you date it. So minutes of meeting. Yes, what you buy, keep a separate bank account. That's that commingling thing. Keep a separate bank account. And then when you pay yourself out of bank accounts, notate why. Whether you're writing a check, doing Zelle, we have that note section. Our stuff it doesn't need to be blank anymore. Earned fee for, or payment for, salary for, whatever you want to put. Start notating what these payments come out for. Right? You keeping it separate. Independent contractor agreements, yes. So you're not going to an employee situation. It's still possible someone could come after me personally. Oh, you were saying if you follow all these rules, can someone come after me personally? But listen, so your question. So I was reading all the things she was saying to have, but it was actually a question. Yes, you have yeah. So okay, we are a litigious society. People will still come after you. The question is, can someone be successful? Can they prevail? You do all these things as long as you don't fall in the exception of the law. What do I mean by that? If you did all these things, but they're coming after you because it was intentional negligence, some type of fraud, those things take you out of the protection. And even if you think about it with some insurances, you have to read your insurances. Insurance will say, we'll cover you, but if something was done under these things, it won't cover you. So yes, they can come after you personally, but if it's not fraud, intentional negligence, or all the, illegal things, and you did these things, come at me all day. You're going to waste your time. And then I'm going to recoup any fees because I'm going to prevail for coming after me. But if anybody that has an attorney, a competent attorney, assesses your situation and see that you have all these things, wouldn't take it. I wouldn't. I'd be like, this is not, no, it's a waste of my time. You wouldn't take it. So let's see. Okay. My company paying my health and wellness benefit for me. No, no. It's just like when we work for corporations or companies that pays those things. What helps you with definitely having a strong argument about piercing corporate veil is documentation. It's how you documenting things. It's how you're paying those things. That will absolutely help you. And there's a way when you do your taxes, right? Those things are tax write-offs. There's a way that happens. So that's showing that's the business that's doing that. There's tax write-offs when you uh, pay yourself health benefits in a certain way. So talk to the tax account, make sure you're doing those things right. So it's really about documentation more than it is our movement. A lot of times we're just moving with informality. It's no formality to it. So it's commingled. But like maybe I told you, okay, well, the money's in my business account, but I got to get the money to go in my personal account. Does that like her? No, I'm notating. Earn fees. So everything is about documentation and how you're showing the separateness of it. And we're not perfect human beings. So the court will look at if you've been operating all this different way and something stood out, because remember, it's a balancing test. They looked at everything with that, the example I gave you with the case with the nightclub owner. It was almost everything showed that way. Well, if you're showing it, it's still a reflection of you understand the separateness and maybe there's something here that you need to get a little stronger on. So you want to just make sure everything you're documenting, you're always doing it within your mind. I'm me. That's that company. Not that's my baby and I can operate the way I want. I'm me. And that's that company. And you're doing an agreement between that entity. Thank you so much, you all. Make sure that if this was very helpful, share with individuals that need to hear it. Go back and listen and dissect this stuff. Yes, I will bring on guests to bring the diverse information, nuggets, education on so many levels, but I also keep trying to make sure I have pockets where it's me and you. And I'm talking about the things that is going to continue to elevate it. So between the totality of guest and myself, let's elevate. Let's do that. So if you can answer those 7 questions, you're not just building a business, you're building a legacy. Don't guess, don't copy, get clear, stay protected, and share with other entrepreneurs. That's a wrap for today's episode of Seek Elevation Experience. I thank you so much for tuning in, engaging. Oh, you guys engaged a lot. Helped me to go. I thank you. Adding value. That's what you did to this powerful conversation. So remember, the more you know, the more you grow, the more you learn, the more you earn. But when you share, you care. So make sure you share. Don't keep this knowledge to yourself. Let's spread the wisdom. And let's continue to elevate together. Until next time, keep growing. And most importantly, keep seeking elevation. Peace and progress.